You will not catch me staring at the sun, not sucking on a dum-dum, not turning round to run. No hallelujahs and no kingdom comes. So you will not catch me staring at the sun. Do you hear that thunder? That's the sound of strength in numbers. Fee, fee, fi, fi, fo, fo, fi. I smell the blood of a million sons, a million daughters from 100,000 guns, not taught by our teachers on our curriculum. Do you hear that thunder? That's the sound of strength in numbers. I am mine. You fight. Not a single thing has ever been mended. But are you standing there and saying you're offended? Go ahead, tell them what I've intended. I say what I mean, do what I love, and send it. Do you hear that thunder? That's the sound of strength in numbers. There's nothing brave and nothing useful. You scrawling your aggro mess on the walls of the cubicle, saying my racing class ain't suitable. So I raise my pink fist and say black is beautiful. Do you hear that thunder? No? That's the sound of strength in numbers.
I'm not ready to go yet, okay? I'm not ready. You gotta wait. I got shit to do. I'm in the middle of something, all right? Just hold on.
Watch your mouth or don't come in here.
Uh-oh. Uh-oh.
Oh, yeah, people, come on, we're adults here. You know what? What is the point?
Yeah, we're adults here. I got a fucking Burger King fucking thing on my head. We're all fucking adults here, guys. People in my chat, 2 words. What are they? 2 words. Let me see the chat flood. Let me see the chat flood. 2 words. Okay, next caller. Please. Let's get into the meat and potatoes, which translate in American to dick and balls.
I got flip-flops. These are my flip-flops. Yeah, I really like my flip-flops because I can put them on. Because look, watch me put them on. I can put them on all by myself. Watch me put them on. Look, are you watching? Look, these are my flip-flops.
Thanksgiving Day. I remember it clearly. It was Thanksgiving Day. I was inserting myself in somebody else's fucking business as a cash grab, and you know.
This channel is harsh reality.
Karen Yak se jodió la sucia vida. Amen.
This is Jonathan Lee Bridges. I have cheeseburgers. I'm gonna put cheese on them. I'm gonna make sure that I have my hamburgers because I'm a big boy now and I can make the hamburgers. My mom lets me use the stove now.
And I'm just like, wow, I like receipts, and they brought receipts. Like they had evidence to back up everything they said, and I'm like, okay, well, there's got to be another side to this, right? Like this can't. No, this is too fantastic.
Yeah, because you're not going to just jump to the conclusion that there's a conspiracy amongst cops to cover up a murder. You know what I mean?
Yeah, I mean cops and just like soccer moms and shit. Like that's what made it even crazier. Like,
yeah, get it, Betty. Yeah,
did you have a close relationship with your mom?
Get it, Betty.
Oh, of course, I still do.
Yeah.
My older sister was kind of sad. She was more of the prissy girl that likes going.
That is the best shit fucking
shopping
ever.
for dresses with mommy. I was the tomboy that liked playing with the people.
Shout out to Cherry for just being easily the most faithful and loyal supporter that I've ever had, man. That someone could have that tenacity with loyalty. And I'm really blessed to have someone like Cherry be part of this channel and in my life. So it means a lot. And yes, I named him after Mr. T and Rocky. Say, woman. Say, woman. Say, woman. Since your old man ain't got no heart, why don't you come down to my apartment tonight and I'll show you a real man. Oh my God, I'm so in love with this little dude. Yeah, I'm gonna go ahead and wrap this one up. I love you guys very, 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 very much. And we will do this again very soon, my friends. Oh, say bye. Say bye. Oh, I love you too. Give me a kiss. Oh, I love you. Bye, guys.
Karen left her
Good afternoon, people. Oh my goodness, you feel that? Oh my God. You feel it? Oh my goodness, people. Y'all see what's going on outside that courtroom right now? Oh my goodness, people. I am so excited. I am stoked right now. Even though I hate to shit all over the mood, even though I really don't expect Bev to do anything, I don't know, ethical. But I am hoping for, at the very least, for her to decide that the jury's each juror's voice matters, and they should be allowed to at least testify in some way, shape, or form as to what their decision was. So hopefully this happens. I'm just not going to hold my breath. But people, there's some definite developments that have taken place. I want to go over a couple of things before the hearing starts. And I want to give a big shout out real quick before I do that. I want to give a big shout out to Tom CPU, Resistant to Silence, LTL Media, everybody who's live, Turtle Boy, for giving a very, very inspiring speech outside of the courthouse, on the courthouse steps. This is what I like to see. No buffer zones, and I like to see people using their voices, man. It's a hell of an inspiring thing to catch, man. So I'm really excited right now because I'm pumped, man. I got to tell you, I am stoked. So I got to tell you, so a big shout out to all of those channels that are, and I know Brandy Churchwell, the 13th Juror, she's streaming this live. A bunch of other channels are, and a big shout out to everybody who is spreading this information. So anybody who is streaming this, if you prefer to watch it here, at the very least, and I'm grateful to you for that, but at the very least, please go over to those other channels who you like and give them a like, catch the replay, support them in any way that you can. Finally, I want to give a big shout out to attorney Melanie Little for joining me last night. I had an excellent time chatting with her and having a conversation about this case. She's somebody who I've been following on this since I've started following this case, since she started following this case and covering it. And I finally got to pick her brain a little bit and chat with her. And I'm really, really grateful to her for making the time to join me here and hang out with you guys. So thank you again, Melanie Little and Team Brittany and Scott for setting that up. I really appreciate you guys for that. So now there's a couple of developments here. One that really concerns me here, but before we get into that, let's just get an idea of what we're looking at today. And hold on a second.
Well, Karen Reed is back in court today, and her attorneys are trying to get two of her charges dismissed.
NBC 10's Manash Kungwari is live for us this morning outside Norfolk Superior Court in Dedham with more on that hearing set to start this afternoon. Manash.
Second-degree murder and leaving the scene of a crash resulting in death. Today, in that courtroom, Judge Beverly Cannoni will hear arguments from both the prosecution and the defense on whether to dismiss those two charges. This after multiple jurors allegedly claim that during jury deliberations, the entire jury agreed that Karen Reed was not guilty of either. Now, it should be noted, Reed is facing a third charge, manslaughter while driving under the influence. At this time, we have not heard if the jury had an answer to that charge. But this hearing comes as NBC 10 Boston is learning of the effects Trooper Michael Proctor is having after this case. Proctor was the lead investigator on Karen Reed's case, and we exclusively obtained a letter sent to more than a dozen criminal defense attorneys who are fighting cases that Proctor was the lead investigator on as well. It was sent from the Norfolk County District Attorney's Office stating Proctor was cross-examined on issues like conflict of interest and bias, and as a result, he's now under investigation and suspended without pay.
Proctor didn't do all the work in this case. There were a whole bunch of other people in the Reed case who did work. Imagine if he's really the seminal key prosecutorial witness in a case. I don't know if I'd be comfortable putting him up as a witness. And so the DA's office may have to consider dropping some cases where he's a seminal witness.
Now, I should mention, based on fairly recent case law by the Supreme Judicial Court, the highest court in the state of Massachusetts, it's actually encouraged, if not dictated, by the district attorney's office to offer up that information to these attorneys. In any event, the hearing is scheduled for this afternoon. Right now, we're live here in Denham. Manash Kongwari, NBC 10 Boston.
All right, Manash, thanks so much. And look, we're going to bring you today's hearing live at 2 p.m. on NECN and on our streaming channels. And then at 7 o'clock, we'll bring you a special edition of Canton Confidential right here on NBC 10 Boston to recap it all.
All right. Now, let's get a little bit more into what they were just talking about here.
Now only on NBC 10 Boston. More fallout from State Police Trooper Michael Proctor. After his damning testimony in the Karen Reed murder trial, Proctor is currently suspended without pay and under an internal investigation. Kirsten Clavin joining us live in the newsroom to explain how this is now affecting the other cases he's worked on. Priscilla, that's right. In legal terms, it's called a Brady letter. And we're now learning 13 separate attorneys have been contacted by the district attorney's office about how Trooper Michael Proctor's conduct could now be brought up in their own cases. In new documents obtained exclusively by NBC 10 Boston, this letter shows the Norfolk County District Attorney's Office has contacted more than a dozen criminal defense attorneys whose cases all involve investigations done by State Police Trooper Michael Proctor. It states that Proctor has been subject to cross-examination regarding issues like conflict of interest and bias, adding that he's under investigation and suspended without pay. All of this following the high-profile Karen Reed murder trial.
Anytime the government is trying to use a witness with this kind of baggage, it will call into question his credibility and whether or not proper procedures were followed.
Joseph Cataldo is one of these lawyers who received the letter. His client was indicted in connection to a July 4th murder in Randolph last year.
I don't know what the Commonwealth is going to do with these witnesses, but I know that we'll be filing more motions.
Other cases likely impacted by Proctor's involvement include a prominent doctor in Dover accused of killing his wife back in 2020, the murder of a moped driver in Milton from 2021, and a child abuse case in Quincy.
No news so far.
Proctor testifying in the Karen Reed trial back in
What about Brian Walsh?
June as the lead investigator reading his graphic text messages aloud to the courtroom.
From all accounts, he didn't do anything wrong. She's a whack job.
An unofficial transcript of his testimony in this case also sent out to attorneys from these other open cases.
I'm sure there are going to be a lot of defense lawyers thinking of really creative ways to try to convince a judge that all this information that happened in the Reed case should be held against Trooper Proctor in any case he was a lead investigator on.
Law experts say these select attorneys will likely file additional motions to get more information on his background.
Even looking forward to the second Karen Reed trial. What are they going to do with him as a witness in that case now that all this is out there? Are they going to call him again? Are they going to not call him? Are they going to, who knows? It may impact how they have to proceed in the second Karen Reed trial as well.
And on that note, Karen Reed does have another hearing tomorrow where the judge will hear arguments to have at least 2 of the 3 charges dropped in her high-profile murder case. Live here in the newsroom tonight, I'm Kirsten Glavin, NBC 10 Boston.
Yes, so many questions as to how that's going to affect other cases. Kirsten, thank you. We will bring you tomorrow's hearing live on our streaming channels, and then at 7 o'clock, we will bring you a special edition of Canton Confidential recapping it all.
All right, so now I don't know enough, but a lot of people are saying, well, what about Turtle Boy's case? Well, Proctor, as I understand it, I don't think Proctor was the lead investigator in Turtle Boy's case. So I don't think that it necessarily applies. But seeing as there are other police officers who are currently under investigation and were directly involved in Turtle Boy's case, I feel like that should have some sort of impact. So I would not expect, or I would not, I would not be surprised in any way, shape, or form if there's now going to be motions filed by Bradel and Betterow. Michael Proctor, what I didn't hear mentioned here was Michael Proctor was the lead investigator, or is the lead investigator, well, was because he's suspended in the Brian Walsh case. That I'm really interested in. I want to know how that's going to impact, because not only do we have the one problem with Michael Proctor being, we have 2 problems with that case. We have, not only do we have Michael Proctor being the lead investigator and completely and totally discredited at this point, and he's the lead investigator in the Brian Walsh case, but there's also the issue with a lot of the evidence being used against Brian Walsh is Celebrite data. And this case right here, this Karen Reed, John O'Keefe case, has compromised the integrity of Celebrite to some degree. It just all depends. So I think it'll be horribly ironic if the Celebrite data turns out to be argued as unreliable in the Brian Walsh case by his defense versus the prosecution trying to claim that it is perfectly reliable. I am really curious to see how they're going to handle that. So this is a mess, people. This is an absolute fucking mess. Geez, man. I don't know, man. I need something. What do I need?
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat. I think we got a super cat.
Little Irish girl, thank you so much. I appreciate you. I don't know if Krusty showed. I know that what's her face, that Andy Dufresne idiot, whatever the fuck her, I think her name is Kim Ferris or some shit like that. I don't know. She's retarded. But she showed up to this stuff. Let's drop in real quick on Tom's CPU, because you know we love to do that. Let's drop in on Tom's CPU. See what's going on out there. He's got Boston Mike up there.
They're under investigation still, right? And if this gets kicked today, meaning that they don't go forward with it, they've dismissed the charge, I think you're going to see a lot of charges brought against the state troopers today or the next couple of days. You know?
Well, we were close. We were close. I was getting dressed, man. Telling you. I was ready to rock out the door.
Well, see, Marissa, you must be new to the channel. Marissa, let me give you a little explanation here. Okay. I would never refer to someone who genuinely is mentally challenged with I would never use the word retarded to describe someone who actually is mentally challenged. retarded is a perfectly good insult that I stand by and I love to use, but I use it for the willfully ignorant. If you are just willfully ignorant, I'm going to call you retarded. And this Kim Ferris lady, or Kim Fair, Kim Fair, is that her name? I don't fucking know, but she's retarded. Capable of, driving a car and holding down a job and things of that nature, and but she's willfully ignorant, so she's fucking retarded as far as I'm concerned. So yeah, just so you know. Moving on. Let's go back to Tom.
But somebody got cold feet or something happened. Something happened for them to pull the trigger and pull back.
Right. Oh yeah.
Something.
Oh yeah. You talking about Josh's office?
Yes. Something happened.
Yeah. That was an interesting thread. It made a lot of sense to me. Like, and sort of because we kind of knew, they'll get up, ready to go, and they got a call to stand down because they probably went up in a couple more lines, or another cooperating witness came forward or something along those lines. But
yeah, it just doesn't make any. Again, glad I'm not making them kind of call.
Yeah, I know. How tough is that?
You know
what I mean?
Oh yeah, exactly right.
That's tough.
Oh,
yeah. Talk about not sleeping at night. Imagine
Now off the subject. There was a I'll be covering the Sarah Boone trial when that starts, but I'm going to keep you guys updated as far as any updates that take place in that case. And apparently there was a hearing today, a Sarah Boone hearing, where a motions hearing, and I think she filed a motion and actually won, where she wants to not be cuffed during the trial. And I got to be honest. Hubbard, can you stop trying to dig into the carpet, buddy? Thank you. I got to be honest. I don't think that her hands should be cuffed. I don't even think her feet should be cuffed, but she's got to keep her feet cuffed. Stop. Thank you. I don't think her feet even need to be shackled, honestly. I feel like until there's reason to think that she is going to be violent in the courtroom, which I don't think she's given any indication that she would be willing to, she was going to do that. I think she should be allowed to present herself as credible as she possibly can in front of a jury. The jury's already going to know that she's representing herself. That's going to be hard enough as it is. I want to see her get an absolute fair shake at defending herself. I think she's guilty as all sin, but she still should get a fair chance to defend herself. So I'm glad that she won that motion today. And there's another hearing coming up where she is arguing that she, because she's only given a laptop about 8 hours a day, I think that what she wants, I think, is she wants a printout of all of the stuff that's actually in words that she can actually read, so she can take it back to her cell. And I think that if she's allowed books, she should be allowed to have at least what can be printed out. Not let her have the laptop in her cell, but to at least be able to have printouts of anything that can be printed out that she can review while she's in her cell if she wants to. I think that that's only fair. So hopefully, like I said, I want to see. I genuinely want to see what she can do. I hope she wins that motion. And looks like Karen is arriving. See what we got here. I see Street Squirrel and LTL there.
Here they go. Showtime.
Sarah Boone is the suitcase killer.
Everybody.
Nice. You guys who don't know, she's the one who killed her boyfriend by leaving him in a suitcase.
Oh, she looks good.
Look at Karen, man.
dude's big. Look at the back of that guy, dude. Oh my gosh. Stady right on it too. That's good.
Yeah, Karen looked like a rock star today. Good for her.
Thank you. You're welcome.
Maniacal Miss, thank you so much. Hi, Will and Sherry in chat. There's a lady there with glare on her
Watch your
t-shirt.
back.
And Tom stream earlier, I think her name is Dina. Yeah, Dina's awesome. Dina's a big fan of the channel.
Oh wow, listen to the crowd.
And we're a big fan of Dina.
Just so you know.
This is wild, man. This is just wild. Look at the support she had. Look at the support. It's amazing. Hey, Ron, you gotta calm down. Hey, Ron, you gotta calm down, buddy. Okay, you bring a lot of negativity in here, guy. You know, you got to learn to relax. Okay, I get that your name doesn't make any sense. It's very strange, Ron. It's a very unique name. I get it, but you know, you gotta you gotta just relax, man, and just learn to find the positivity in things. Hello, Liz Reed. It's good to see you. Of course, all of our love and support is with you and your family. Karen, of course. There's Street Squirrel. There's Dina. There's Karen's dad. Karen's brother. There's Rita. Just saw Paul. There's Scott McGinnis there.
There's Rita.
What's up? Sorry. Good. I'm gonna try and get up here. Thank you. Finally. Yes. Yes. How are you? I'm scooting right behind you. I'm gonna try and get up on the. No. I want to try and get somewhere high so I can see everybody here. Hi. How are you?
Good. How are you?
We'll see you everywhere.
Yeah, I know.
No, everybody. Good to see you. Yeah. Hi, sweetheart. I'm doing great. Thank you. It's very good.
Did I stand on the first step or do you only off?
That's wild, man. Look at all those people, dude. Like, there's a bunch of people across the street, too. This is wild, dude.
Yeah, I'm just trying to get an aerial view, guy. So, I guess we can't use the steps. We're not allowed to step on the stairs. Again, we might break them. I just got yelled at for standing on the stairs.
We're sure. That's the
I know. Like,
I can't see any. Yeah, I have a costume that. Oh, no, and it's down there. Okay, yeah, David, my daughter loves it. Put it in your my memory. Yeah. Sorry,
Now, guys, we're gonna see. Hopefully, we'll get to see this this new member of Karen Reed's team, Mr. Weinberg. We'll get to see him spit out some argument, hopefully. And if not, at the very least, hopefully we'll get to hear The cerebral assassin, the cerebral ninja is what I like to call him. David Yannetti, the cerebral ninja. I look forward to seeing them argue these motions. Because I just don't see how you can deny this. Karen Reed has rights. Yeah, look at all these insane rabid animals. Just look at they're wild, man. All right, let's switch over. We're going to switch over to the hearing now. All right, there's Karen's parents, some of the nicest people I've ever met in my life. Mike D, double up with the bill, most definitely. It's been too long since I could catch a live, but I always watch them after. This is for Karen, you, and of course the song. Right on, man. Thanks, Mike D. Appreciate you, buddy.
You guys pushing it live? We're sending it out to the other station. We're sending out over 7. Okay. Well, I don't think we're podcasting. We're just.
Gosh, Karen looks rested, ready to go, man. This is I got a really good feeling about today. Very good vibes happening.
I know. Well, that's interrupting a lot of things. Absolutely going to interrupt you. That's going to. Wow. I was going to say, now, what'd you get for this work? Fantastic. That archery, the fire. Just. Yeah. Now, is that air or
I will get to that. Yes, I will talk about that. I promise. If Cherry can find that somewhere, that would be fantastic. I would really appreciate it. What's up, Chris Loring? Good to see you, buddy. And for those who don't know, that song that people are referring to, the song that I play before these hearings and close out, and I usually have in the trailer, that's JC Loring here, Chris Loring, who does it. Fantastic talent. And yeah, we're gonna go over yes, Cherry, I'm asking nicely, please. We're gonna go over that provided Cherry can find it, which Cherry can find just about anything. We'll go over that when this is over. And there's Officer John O'Keefe's mom. We got the cerebral ninja's got to stay hydrated, folks. David Yannetti has got to stay hydrated. And there's Paul O'Keefe and his wife. Both testified during the trial. Paul is John's brother and testified during trial and strangely didn't have anything bad to say about Karen on the stand. But in TV interviews that he's done recently, seems to be a little bit different. And Good Citizen, thank you for the Venmo. I appreciate you, Good Citizen. I got to meet Good Citizen when I went to Dedham. Very, very sweet, amazing person. Now, this looks like the same courtroom, doesn't it? What's up, Scott McGinnis? Good to see you, buddy, as always.
Right, Charlie?
Oh, you popped. You're gonna be famous.
Here it is. Here it is.
Stop!
This is Ken.
Hitty, all parties having anything to do before the Honorable First Justice Beverly Canoni, now sitting in the Norfolk Superior Court within Fuller County in Norfolk, Rodney, if you pretend that shall be heard. God save the Commonwealth and the court.
The committee around what I heard on behalf of Karen Reed, who sits to my left, and co-counsel David. Thank you, Your Honor. May I use the podium? Thank you.
All right. Mr. Weinberg, you're going to see what this dude's made of today.
Judge, there are two central issues.
Of course, the sound goes bad. I'm only getting sound through one speaker here. That's not my fault.
I just want to make sure I hear.
On a day like this, I'll keep my voice. Okay. Thank you, Your Honor.
Yeah, like
There were two central
Austin messed up their sound. Austin 10.
to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there is strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted.
All right. Hold on, guys. This seems to have better sound.
There are two central issues.
A little behind, but it's the best I can do.
There's not one for amplification, there is one for recording.
I just want to make sure I hear.
On a day like this, I'll keep my voice.
Okay.
Thank you, Your Honor. There are two central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there is strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court, but it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court, and in fact believe it will convince Mr. Lally and the district attorney's office that that jury.
This is the best sound I could find. I tried 3 different channels.
Reached a decision. It will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2, and the lesser includes the manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally and the prosecution or the defense, that in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to 2 constructions. One, that their impasse covered all 3 counts, and therefore would lead ineluctably to a mistrial declaration, or 2, that the impasse was on 1 count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court, neither did counsel. But the issue now, and again, it's in the context of double jeopardy, which is such an historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign at that point, the king, against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury.
There you go.
Which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact
5
that
jurors.
these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. And the second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of
lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here, what we know is that 4 jurors reached out to defense counsel. Jurors A, B, D, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't denounce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory, and that makes them more trustworthy. They corroborate each other, and I contend.
I really like this guy.
Left on Mr. Lowry's phone, which he responsibly shared with counsel and shared with the court, essentially saying,
smart move.
This is probably one of the 4 jurors, but we don't know for sure. Says essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity.
This dude is fantastic.
We now have the declarations of the jurors through the defense counsel. We have a voicemail of 1 juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors did. Not one of them,
wow,
to my knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and emotions, I don't agree with that.
Wow.
No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I tried to say, the legal framework here, the landscape is not quite as crystal clear as it is in the standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, Form is not to be exalted over substance. They are making that point. I mean, I've done this for 52 years, and the procedures in court to inform sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, where there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call a central proposition, which is, where's the default? Is the default from not asking the jury about these other counts, that this Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute it when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, and I remember it because it was the tail end of the Warren Court, and it revolutionized criminal justice, and it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Matthew, Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleadings, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing
wow,
with
this guy is good.
capital punishment, with whether the punishment should be life or death for the Sonaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said, bring back these 2 jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago, in a case dealing with a lawyer's allegation that there had been a racial statement, it's called the McCallum case, 485-90, it said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where the lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing, questioned the people who were connected to it before order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence, that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during, that the jurors had accessed the internet when they were judicially prohibited from doing so, courts reconvene hearings, and I can test that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. Why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict?
I love this guy.
What about count two?
I love this guy.
What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, sorry, we authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyers' affidavits and affirm that they're accurate, or alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion.
This guy is
in terms
awesome.
of how to get to the bottom line.
This guy is fantastic.
Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure if legally you would, but to keep this private and keep this confidential, because we don't want the jurors to, risk
Of course not.
identity.
Nobody wants
Your
that.
Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence it was not, to establish a procedure consistent with McCollum, consistent with Tsarnaev, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, where there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from an improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Luford case, or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser.
This guy he's getting in front
I am
of
hopeful that the
Lally.
prosecution
Fantastic.
will join with us. not seeking a new trial.
I love it.
If they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel, this was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our
52
system
years.
of justice. People say it's not perfect, but it's the best that the world
Karen
has.
got one of our forefathers on
This
her
to me
defense
is
team.
hallowed ground in the courthouse, named after someone
That's awesome.
who's a friend who I deeply respected. I want the prosecutor to get the facts in the best way we can at this point in the case, which is through your honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, that she was acquitted.
Wow.
This
dude is amazing.
Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford. There was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps through many years of doing this, that acquittals count. If she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote.
That's it.
And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be requested.
This dude is amazing, bro.
Let me switch from the acquittal, its implications, to manifest necessity.
Bev loves him.
In this case, we
Bev
have
loves this guy.
explicit guidelines which have been set out by the Supreme Judicial Court.
Bev loves this guy.
Look to whether or not there was manifest necessity for the declaration of the mistrial. Manifest is a word that says to show clearly, and whether the mistrial order was avoided,
Bro, look
whether
at
there were
Bev.
viable options, whether the court is
She's like,
had no choice, no options. But here at minimum, with 4 or 5 jurors saying we believed her to be innocent, we believed there was a vote. There's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 constructions. So this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count.
Oh yeah, that dude is Bobby
Here's
Duvall
where
all the way.
The court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the defendant, on the government, on the prosecutor to justify a mistrial. The SJC has issued multiple opinions. I'll read just a couple. because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, was one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity, says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass 816, 2008.
This guy is unfucking believable.
To satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial in the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nickel. I have a copy of the Nickel decision because it's the one that was not referenced yet for your Honor's consideration. Nickel was an interesting case. It was a driving case, jury of 6. There was a belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that this is in fact a rule of criminal procedure, and that defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant, make them go to trial a second time in the face of double jeopardy's manifest necessity requirement, or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser includeds. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on manslaughter, what about involuntary manslaughter? What about OUI? But this is different because we have 3 counts, not 1. And Rule 27B, that you were...
That's what I said.
We contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on.
I love when lawyers validate my shit.
That rule had it been...
I said the same thing when I went over the opposition motion.
You provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, but provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are the legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those two guiding principles were met by the evidence of what occurred on July 1, where we have the chronology of Your Honor taking argument from counsel regarding the warning note, and the prosecutor didn't want a TUI instruction. Defense counsel did. Your Honor elected to give a TUI instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Yannetti of Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. Again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate lawyers to succeed in reversing the judge's not providing an instruction that later they learn. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, in Nicole, the Appeals Court in a case, Commonwealth versus Oregon, we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying the mistrial rests on the prosecutor. And so again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge
Fantastic.
may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised your judge.
Nice.
So this was a case that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria, a full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor that this is not easy. This was a long trial. Prosecutors had strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of a mistrial. And they should want, I submit, in a search for justice in this courthouse, where we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, central of double jeopardy. Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure with Your Honor's discretion.
I love it.
It either allows the defense lawyers to supplement the declarations with juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. If Ms. Reed was acquitted, bring the jurors in, Judge, hear from them. Thank you. It's the right thing to do. Thank you very much.
Wow. In other words, Lally,
Get the fuck out!
You suck.
Your Honor, Commonwealth would ask, request that the defendant's motion to dismiss be denied, as it was not.
Speak up, Mr. Lally.
Counsel had more than adequate opportunity to be heard and object to the declaration of the mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel is asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking or the right of a court to take partial verdicts.
More attempts at misdirection.
If that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce.
He looks extra peppy today, doesn't he?
Polling the jury who has declared repeatedly to the court that they're in an impasse. So simply put, Rule 27B is not.
He must have had his latte grande enema.
When it comes to each of those respective points, the jury in this case, when one did not return a verdict, and two, counsel had adequate and ample opportunity to object to the declaration of mistrial, and three, that the mistrial was declared out of clear manifest necessity, which the court, the case law has repeatedly stated is the prototypical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries.
I mean, that's not me. I don't know why. Okay, there we go.
There's quite a twisting of logic into sort of a pretzel in order to have the circumstances of this case.
Twisting logic into a pretzel. You hear this guy?
An unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. And as the court is well aware, that's a case in which, following jury deliberations and defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation in which the verdict slip was marked.
Of course he has less hair. What do you think? It's going to grow back?
That case stands for the proposition that's where those slips were in contradiction of the jury's report to the judge in open court, that they were deadlocked. That does not.
That's not me either. All that fumbling around and stuff.
Does not contravene or overrule the verdict as it is applied in open court.
That's the cameraman twisting a pretzel.
And I think it's directly applicable to what's been provided to the court so far. It states it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is a contravention to that case.
Well played, Matty Cakes. Well played.
In Roth, in Gray, in all of the cases over the decades and centuries dealing with this, Rupert itself states very clearly the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes in Commonwealth versus Carn as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, it was provided with written copies of those instructions that the court gave. That stated on at least 9 or 10 different times exactly.
Cherry gets instructed orally too.
And how to come to that unanimous verdict and how to report that unanimous verdict. And there is no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was checked. Neither was checked. Neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth was doing, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case.
Rude, really?
Special about this case. There's no special application.
Tell her that.
Procedure that needs to be developed, created, and employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the court referred to them as an extraordinary jury, and I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury submitted, which Commonwealth would submit, were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they had reached an impasse as far as their deliberations were concerned, as it pertained to the charges. In the final note that was submitted to the court, they referred to the charges in the plurality.
I still have the blue cup.
Twice within that.
This one's better.
As it pertains to exactly what they were saying. When it comes to what they were communicating and reporting to be at an impasse in regards, they referred to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it be personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt just looking at the affidavit from the one juror in regard to the
What the fuck are you talking about?
That allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that, that is exactly what the case law advises against and governs as far as taking this sort of post hoc weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel had to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Yannetti was asking for Arturo Rodriguez. And understanding that asking for Arturo Rodriguez is not equivalent to requesting a mistrial. It's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not
cunt
that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, or reported to be at an impasse. Counsel, and these are Mr. Yanetti's own words, on both occasions, indicated that from them, or argued for Arturo Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about is for this trial at those particular points, or at least leading down. Now, as far and this is also, again, as I stated, backed by the case of Ray versus Commonwealth states. Counsel's request for Arturo Rodriguez instructions permits, quote, the inference that both parties were provided an opportunity to confer on possible alternatives to mistrial.
You need to shut the fuck up.
Is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case and this particular trial. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of argument against the court's decisions when it came to anything that was even a perceived slight measure against the defendant's interest. And I would direct the court to the verdict slip argument that was made post-trial as well.
Shut up! Oh my God, I don't care!
Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that a prototypical example of the manifest necessity is a deadlock jury or a hung jury. And that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Unetti during his arguments for the Julie Rodriguez recognized.
You're lying. And you're a piece of shit.
The dangers of coercion when it comes to a deadlock jury are amply stated throughout the case laws.
Oh my God, dude. You've got to be fucking kidding me with this. It's a deadlock jury on one fucking count.
Required and has never been required, and that goes from the Luther decision from the United States Supreme Court to the Supreme Judicial Court of this that there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those.
Stop breaking the law, asshole!
Whether or not they have a partial vote. I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when you're talking about charges with lesser included or charges that have a multiplicity of different findings that the jury can make. Because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty equal guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a poll. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe as far as not allowing for the court to inquire into those types of scenarios. So I guess the defendant's position is the court should have polled or inquired only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know if there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to those types of coercive pollings of the jury while they're still deliberating. The notes and the communications from the jury, again, on 3 separate occasions, and very deliberately, as far as the language that was used, declared themselves to be eminent as on 2 separate occasions, the last of which included language to the effect that any further deliberation would be futile. That is the very definition of absolutely no alternative other than to declare mystery. And it is clear from the language of the jury's communications to the court, and it's clear from the case law and the rules and the law itself as far as what the court can do. The 2 areas that counsel is talking about and sort of asking for extension or creation of new law, again, sort of
Creation of new law. Listen to this asshole. Creation of new law.
In which the court can make post-trial inquiry have to do with some sort of bias if there's an issue raised in regard to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes. Or in an instance, I'm sorry, one moment.
Today, Junior?
And in an instance in which there is some sort of allegation or some sort of evidence of extraneous influence. The defendant's not raising either of those issues. Specifically within those cases, what the court states which is obviously binding on your own, is that those carve-outs for extraneous influences or bias on the part.
Look at Karen. She's like, somebody fucking kill me right now. This boring fuck.
Is any inquiry into the delivery process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades. Commonwealth versus more states specifically.
Oh my God,
Massachusetts continues to appear to Commonwealth.
Shut your fucking mouth! Shut the fuck up, you cunt!
And any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Now, the reason that the Commonwealth did not respond directly to the jurors when it came to them expressing or wishing to have discussions about their deliberative process or their votes is specifically for the Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates.
Sit down, Mr.
Simply
Lowry.
because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate
Nobody's saying for you to do that,
still
dickhead.
does
Nobody's
not
even
allow
saying for you to do that.
for the court to then have these conversations with these jurors that delves into their deliberative processes or their deliberations.
Nobody's saying to do that.
Specific type of coercion that is feared by the courts when it comes into this in sort of condensed quote from Commonwealth versus Law. And it states simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was a product of a thoughtful and thorough deliberation process.
Totally, Brass.
The
Thank
risks
you.
of jurors' coercion are too high, and the liability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from the deadlock jury. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, it's prohibited by the law, it's prohibited by the development of case law over decades and centuries as to what is permitted. Certainly, the Commonwealth nor anyone wants to try someone who has been acquitted by a jury of their peers or retry them on the same case. That's not what happened. There was no verdict returned by this jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration of this trial. And the court did absolutely nothing in finding a manifest necessity as the only alternative.
You see what he's doing?
that could have been
Saying the court did nothing wrong.
the jury then, polling the
The defense
jury,
never accused the court of doing anything wrong.
rules, it's not appropriate, and therefore the defense motion should be denied. Thank you.
Can I reply, please? Thank you. There were two cases that Mr. Lally relied on, and they both stand for very different propositions of law. Commonwealth versus a juvenile, it's actually juvenile versus Commonwealth at 392 Mass 52, 1984. Says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, we deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. two separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Commonwealth versus juvenile was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on this sort of proofs. And that's the principle of Commonwealth v. Roth, the other case that Mr. Lally referred to. That case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser includeds. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser includeds, the court prohibited such questioning as to lesser includeds. But the court distinguished throughout this lengthy SJC opinion. Our case, we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges.
There you go. Like, it's
Both
real easy.
Bluford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. In the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Bluford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they were. They needed to decide all of the different allegations within a single charge, and they came back and said we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge.
Wow.
We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached 2 decisions, 2 general verdicts, but we're in an impasse on a 3rd one.
Dude, how do you argue with that?
The Commonwealth talked about the risks that some of the jurors might be exposed to media, and that's certainly more than true in the Sanaif case, where they've had, just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013, the government's investigation, the trials. Jurors knew what one jury decided, and yet the First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. Judge, you're an experienced jurist. I trust you to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end to determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Lally's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberating jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we have a verdict, which is, did you unanimously determine as a final determination that Ms. Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision? In terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted the mistrial, he could have asked for a mistrial then. Your Honor would have, of course, had the discretion to deny it after 4 or 5 days of deliberation. He asked for a TUI instruction. And it's inferred by a TUI or a Rodriguez instruction in the state court. TUI, I think it's a 19th century federal case, is that you have hope when you're asking for the TUI instruction. My experience, usually the prosecutor who's confident in the jury that wants the TUI instruction to try to get the majority to overcome the minority and get to a guilty verdict. Here you have the defense lawyer asking for a TUI instruction, reflecting that he wanted further deliberations. So it's no answer, and the Ray case does not say that when you ask for a TUI instruction, you are really asking for something more than a TUI instruction. TUI means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those two colloquies on the Friday before and then on July 1. We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge?
Just hear the jury out. That's all the defense is asking. Just hear the jury out.
Stop the re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence.
There you go.
The second 12, when she's already convinced the first 12. Thank you, Judge.
There you go.
Any responses to that?
Fuck yeah, dude. This dude is amazing. Thank you, Ms. Bell.
Football rise.
So is she going to reach a decision now, or?
All right, thank you very much. I'll take this under advisement.
I'll take this under advisement, is all she said. So I mean, does that mean that she's going to come back with a decision today, or she's just going to? I mean, so what we've got going on here is that the defense is merely asking her to perform a voir dire, to question the jurors on what their decision was, not how they came to the decision, not what was discussed, just what did you vote on? Ask each juror, did you vote not guilty on this charge? Basically, the same thing as polling the jury, just under oath. So I don't see the problem there. And Lally's having a completely different argument. He's saying, well, you can't have these discussions with the jury. You can absolutely find out which way they voted. You can't ask them why. You can't ask them how they came to that decision. And that's not what the defense is suggesting they do. And this dude, man, this Weinberg gentleman, oh my God, this guy was fantastic. I was blown away, man, because dude was straight up. At no point did I hear him put the blame on Judge Beverly Cannoni. And Lally tried to paint that picture as if that's what they were doing, because we all know it's Beverly Cannoni's fault that this happened. She was really quick to call a mistrial. We know that that's what happened. But this dude was real smooth. And he pointed out the fact that he said, okay, she worded it. She said, we want you to come to a decision on each charge. He quoted her. He quoted her in saying, we want you to come to a decision on each charge. So in lieu of that, and the fact that he didn't make it seem like this is like, not only did he use the words, like he didn't even use the words. You know how these people love to say, my brother in the law. He didn't use those words, but he made it feel like he looked at Lally that way. Like Lally was a brother in the law. And he was saying things like, I hope that the Commonwealth, Mr. Lally, will join me, will join us in getting justice here. I mean, this dude was surgical in being a very nice man. Oh, I totally see Bobby Duvall playing this guy. Like, I totally see it. That's what Bobby Duvall does best. Plays the nice, like, look at him in Falling Down. Think about Bobby Duvall's character in Falling Down. Just real nice, you know, doesn't take any shit, but is real nice, you know, a nice old man. This guy, like, he had Beverly Cannoni hypnotized, bro. Like, hypnotized. Just by his sweet demeanor. It's fantastic. Right. He's the good cop element in that defense team that it needs. Because both David Yannetti and Alan Jackson, as much as I love it, the fact is they're both aggressive as fuck. You know, even Yannetti, like with his, I love Yannetti because like he's aggressive as fuck, and then he like apologizes. I'm sorry. I love that shit. I love that shit. His whole style is just like, oh shit, I'm sorry. I love that about Yannetti. I fucking love it. But this dude was just like, it was like Santa Claus, dude. Telling Judge Bev what a good girl she's been all year. And if you want all those Christmas presents under your tree, do the right thing, Judge. This guy was fucking fantastic. Oh man, I ate that shit up. I'm not even gonna lie. I ate that shit up. I heard a rumor, and I don't want to say the rumor, but I heard a rumor. I want to check in on. But let's just go into this first.
I don't know, but that was a good move. I like that. You see that? Out of the way. Good luck. Good luck.
Look at how nice Karen's parents are. Oh, okay. Yeah. Thank you. Appreciate it.
Good job, Dad. Good job. Are you gonna move? Let's go. Let's go. Keep moving. Let's go. John. Let's go.
Hey, Karen. Thank you.
Yeah, I want to know who that cop manual was.
I knew. Right.
You don't need to. I got it.
Weinberg's got the mullet going. Business in the front, party in the back.
I mean, he does. Weinberg's totally business in the front, party in the back.
Somebody walked into that, you know that.
Oh, yeah.
Oh, yeah.
That cop is doing an excellent job.
Yeah, the MSP is doing a great job
Kudos to him.
protecting
He
him.
knew Weinberg needed help, and he just absolutely just took him. Yeah,
Yeah,
that was nice.
See, this is why we back the blue, guys.
True.
There's still good cops out there.
I love the rat tail. Look, that's OG.
Okay. Pleasure to see you again. Nice to see you. Take care.
That's awesome, Beef. That's awesome. Look at that right there. Party in the back. That's right.
That's Boston Mike on Tom Street. Awesome.
Yes, let's go, folks.
Great. Thank you. Hey. Another day in the books, bud. Now what do we do, right?
You wait.
It's just like, now what?
Did Weinberg just get left out of a vehicle?
All right, let me hold on a second here. Sorry, I'm just checking something here. Sorry, I'm looking into something here, but
Great camera. And her brother walked by and shook my hand again. So, you know, they're genuine people.
Very genuine. And we're going to keep out here fighting. Doesn't matter if we're out here in the heat, we're out here in the cold. We're going to continue to be here. And I'm sorry, sir, your name?
Bob.
It was a pleasure meeting you today, Bob. I hope I see you again.
Oh, thank you.
All right. If you need anything, you let us know, okay?
All right.
All right. And that's Bob. Thank you. And if you go on YouTube, you can look me up, LTL Media.
LTL? Okay.
LTL Media.
Okay.
All right. It was a pleasure meeting with you and speaking to you today.
Thank you.
Absolutely. Thanks for coming.
Okay.
We appreciate it. And that's...
all right. Seemed like a really nice guy. All right. Sorry, I'm trying to find something here, but I can't seem to find it. But let me go over this because one of the biggest problems right now one of the biggest issues right now is how Michael Proctor being involved in multiple investigations, being the lead in multiple investigations, how his conduct in the investigation into the death of Boston police officer John O'Keefe, how is that going to affect the integrity of the other investigations? That's a big problem. This is not something to take lightly here, folks. So apparently there was a letter sent out. Let me go over this real quick. And this comes out, this is from Michael Morrissey's office to defense counselors, multiple different defense counselors. And it says here, this letter is to inform you that pursuant to mass criminal blah, 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 the Norfolk District Attorney's Office is aware of information that in Commonwealth versus Karen Reed, Massachusetts State Police Trooper Michael Proctor testified and was subject to cross-examination relating to alleged conflicts of interest, communications with non-involved civilian persons regarding the case, and statements regarding the defendant from which defense counsel argued a bias could be found. In addition, this office is aware that Trooper Michael Proctor is currently suspended without pay pending an open internal affairs investigation by the Massachusetts State Police. Attached is an unofficial transcription of Trooper Proctor's testimony on June 10th and June 12th, 2024. That was compiled using SpeakRight from the court media pool feed obtained from Court TV and Canton Community Television websites and was proofed by this office. While best efforts were used to achieve accuracy, this is being provided for discovery purposes of the statements made, but is not official transcript amenable for impeachment purposes. An official transcript has been ordered to the extent that testimony references prior proceeding and text messages from through and proceeding pursuant to Massachusetts criminal blah, 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 blah. Such material is subject to a judicially signed federal court order and is not within the control of the Norfolk District Attorney's Office. Requests for information should be made to the United States Attorney's Office pursuant to blah, 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 blah. Okay, so this is interesting. Let me read that one more time. To the extent that the testimony references a prior proceeding and text messages from through and proceeding pursuant, blah, 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 such material is subject to a judicially signed federal court order and is not within the control of the Norfolk District Attorney's Office. That means that the United States Attorney's Office has control over this stuff, which indicates to me strongly that this federal investigation is still very open. So, and it also sure as fuck seems like the Norfolk County District Attorney's Office, specifically Michael Meatball Morrissey's Norfolk County District Attorney's Office, is trying to separate themselves from Michael Proctor. So this is very, very, very interesting. Because if Michael Proctor is, if the Norfolk County District Attorney's Office stands by Michael Proctor, this is going to look really bad for them when it comes to this federal investigation conducted by Josh Levy at the U.S. Attorney's Office. So, yeah. This is real bad because there's a whole lot of cases And one that wasn't mentioned was the Brian Walsh case, which is my biggest concern. That was my biggest concern. Yeah, this is a big problem, man. This is a big problem. Because it's not just a big problem for this is why this affects the public so poorly, okay? In such a bad way. This is why you have all of those people standing out there demanding justice for Boston police officer John O'Keefe, demanding justice for Karen Reed, and demanding and not just showing up at these hearings, but they're also doing standouts, protesting Michael Morrissey's office. This is why, because what this does when you have a dirty motherfucker like Michael Proctor working at the Massachusetts State Police, and he's doing the things that he's doing, and if he's working directly under the tutelage of Michael Morrissey's Norfolk County District Attorney's Office, and the cases that are open that they are in charge of prosecuting, of investigating and prosecuting, if the integrity of those investigations are fucked, and the perpetrators, the suspects, the ones who are actually charged are actually guilty, and they can beat this in court and go free because of Michael Proctor's behavior, because of the dirty shit that Norfolk County DA's office engages in, what that does is that puts the public in Norfolk County directly in danger. It puts the people of the Commonwealth of Massachusetts directly in danger. This is why these people are standing up. This is why people are arguing and yelling and screaming at the top of their, not arguing, but yelling and screaming at the top of their lungs, wanting justice. Because this is how corruption costs justice. This is a prime example of it, because now the integrity of so many other investigations are compromised. So many open investigations right now are compromised. And if those suspects, again, are guilty of these crimes, now the public is directly in danger due to the fact that the integrity of these investigations are compromised because of the corruption, because the credibility of the Norfolk County District Attorney's Office and the Massachusetts State Police are compromised. The credibility is fucked. And this is something that defense attorneys can argue in court. It is absolutely microdots, and thank you. Make sure to sub up to microdots, guys. It is absolutely a public safety emergency. It is a public safety emergency. Massachusetts has a major problem right now. And this is why a lot of people are feeling like, hey, just let sleeping dogs lie. Things aren't that bad here. Just let these dirty motherfuckers do what they do, man. Fuck it. It's not worth it. A lot of people feel this way. But make no mistake that a lot of people also are like, well, it is what it is. We live in a justice system where everyone has rights, and even the guilty have rights. And this is a sacrifice that the people of Massachusetts are willing to make. in order to fix the problem so that this shit doesn't happen anymore. But it sucks, you know? But make no mistake, it is not the people of Massachusetts' fault for demanding better of their elected and appointed officials. It is not their fault for demanding better. It's those corrupt fucks that they're protesting against that are at fault about this. It's nobody's fault but theirs. They should have lived up to the oath that they swore to uphold justice. And sacrifices happen when you have to stand up and do what's right. You have to stand up for what's right, and sacrifices have to be made. And sometimes guilty people are going to have to go free, and that fucking sucks, but it is what it is. It's so that you can ensure that this shit doesn't happen anymore. And that the people of Massachusetts can live under a blanket of safe comfort, a comfort of safety. I hate that you have to go through this. You locals that live there, I hate that you have to go through this. But I got to tell you, I admire the fuck out of you, every single one of you, for standing up, understanding what the risks are, understanding what the repercussions are. I commend you for having the guts to stand up and demand better. Exactly, Michelle Bowling. Exactly. It could happen anywhere. I mean, these are the people who did not want a police audit. The people who didn't want the police audit were made up of McAlberts and people who feel like we don't want to find out what we're going to find. Because what's going to happen is there's a lot of open cases, and the integrity of those cases are going to be fucked. And bad people are going to go free. But we can't let I mean, imagine a world, imagine a country now where a defense attorney can reference back the Commonwealth versus Karen Reed and how Celebrite data became unreliable. Imagine what precedent that would set. Imagine that. Imagine living in a country where Celebrite data is no longer credible. All because Michael Morrissey's district attorney's office wanted a win. That's not okay. Can't just let that happen. You can't just let that happen. Yeah, exactly. I mean, this is how serious it is, people. Those of you who are just now following this case, this is the reason why everyone's so passionate about this. Make no mistake about it. This isn't about what's popular. This isn't about something that's fun to talk about. This is about a very serious problem that could set a very dangerous precedent. When you have corruption, this is the ripple effect that corruption in one county out of one state in this country, this is the ripple effect that it could cause. And that's just one ripple, is Celebrite data and it being used to convict a guilty person who murdered someone. At least one person. Who knows? But how many cases, if you people follow true crime, how many cases have you followed where they use Celebrite data as evidence to convict someone who was guilty? You think that's just going to fly just in Massachusetts? No. This, if Karen were to have been found guilty, due to a rigged system, then Celebrite data would have been fucked. The reliability would have been fucked. All because the prosecution felt it was worth risking that in order to get Karen Reed falsely convicted of a crime she didn't commit. It absolutely helped, Cherry. It was presented as evidence to convince the jury that she, I mean, how much time did they spend on Letitia's Celebrite data in that trial, Cherry? I mean, we're talking, I mean, it was almost the whole day that they were going over her searches. Bukaki's missing dentures. Thank you so much. Can Proctor file for unemployment? Just curious. I don't know. It's a good question. I mean, yeah, they wouldn't have found him. We're talking about an 11-year-old boy who was brutally murdered by his stepmother in Colorado Springs, Colorado. Okay? His name was Gannon Stauk. His stepmother's name was Letitia Stauk. And Celebrite data was blasted all over that trial to help, to not only to help locate Gannon's remains, but also to show the jury what her search, how to show the jury how damning her searches were, how suspicious her searches were. They were incredibly suspicious. That's just one case off the top of my head. Right. Exactly. Exactly, Cherry. Because, like, thank God that this, they were, what were they doing? They were doing something for the city as far as like the water level or something under that bridge. And that gentleman just happened to find, they do that every 2 years. They just happened to find his body. Yeah, this is the reason why. This is the reason why the locals, and some of us who aren't local, but the locals are so passionate about the Officer John O'Keefe, Karen Reed case, because there is so much corruption and it's so bad that it is going to affect other cases. And the people who live there deserve to live in peaceful, in a peaceful mindset. They deserve to live at peace. They deserve to trust their justice system. They deserve to be able to take comfort. What's up, Miss Shorty? Yeah, guys. I'm gonna go ahead and call it, but I got a couple of quick announcements. Tonight, this evening, I will be on Miss Shorty's channel. Jesus, what time did we agree on? I think it was 9 p.m. 9 p.m. Eastern. I will be on Miss Shorty's channel. I'm grateful that she's gonna have me on as a guest. And I am going to also now Monday. I'm really excited about this as well. Monday, I will be live at 6 p.m. Eastern on this channel, and my special guest will be Mizzy, who is so instrumental in making sure that Sandra Birchmore's story is out there in the open and people are being educated on this case. Mizzy is going to be my guest, and I am so excited about it. Mizzy is going to be my guest on Monday. I haven't said it yet, but I'm going to set it probably tonight. But Mizzy will be my guest Monday at 6 p.m. Eastern. And we will be discussing the Sandra Birchmore case, and she will be a guest here to educate me and anyone else who is not very well versed in this case, like myself. I am counting on her to enlighten me as best as I possibly can, and I want to share that experience with you guys. And Microdots is excited about it. I think that there's going to be some exciting stuff happening between Microdots and Mizzy coming in the future soon as well. So I'm really excited about that. And again, I had a blast with Melanie Little here last night. We had so much fun. It was a great conversation. So if you didn't catch that, catch the replay. It's still up. And I think she's still live. I'm not sure if she's still live, but I think she is. So make sure to go check her out and give her a like as well. And I realize some people here are, who are new. They're like, I don't like the sound effects and I don't like the videos. Go fuck yourself. That's how I do things here. This is how I've always done things here, and you can kiss my balls. But there are other great channels who don't add sound effects and little video clippets and things of that nature. And you can go watch them, and no hard feelings towards you for that. But for those of you who did join me and you enjoyed the stream, I am grateful to you, and I'm really glad you guys were here. Thank you guys so much for joining me. Thank you guys for liking this video. Please make sure to like it on the way out if you haven't already. And subscribe if you're not subscribed already. I would really appreciate it. And all you new subscribers, I'm grateful to you, and thank you guys all so much for all your support. And again, remember, 9 p.m. tonight, Miss Shorty's channel. I will be a guest on that, and I'm really looking forward to that. Guys, I love you very much. You guys are absolutely fantastic. And we will do this again very soon, my friends.